Pronunciate, please.
Respectfully, my lords, my name is Adeboyega Awomolo. My lord, ADEGBOYEGA Awomolo, AWOMOLO. Suraj Saida, SN, SURAJ, SA-EDA, Mutalibi Adebayo Ojo, MUTALUBI, Ojo OJO Adebayo, ADEBAYO SAN. And that appearing with us for our Malana friends, SH Bakun, BARKUN, Abbas Olaiwola, AWBAS, Olaiwola, OLAYIWOLA, Akinyosoye Aresoyin, AKIYOSOYE, AROSANYIN. Made, is Made here? Right, the last but not the least, Ayodeji Afolabi, AYODEJI, AFOLABE, BI. My Lord, we are preparing for the prosecution. Thank you, my Lord.
Yes, defendants.
Nnamdi Kanu, MAZINNAMDIKNU, appearing pro se.
Thank you.
Thank you, my Lord.
Thank you. Before I delivered the judgments, I think it's just unfair to call the defendants, because after the judgment was reserved, while reading the file, I observed that some processes were filed. Defendants, can you identify these processes and let me know what you want to do with them?
I am most grateful, my Lord. We have joined issues on the motion on notice, my Lord, asking this very honorable court to refer certain substantial constitutional questions arising in this very trial to the Court of Appeal. That's the first one.
Defendants, please.
My Lord.
While you identify your motions, tell us the date on the motion and the date you file same.
Thank you, my Lord. Most respectfully, my Lord, this motion on notice was dated and filed on the 12th day of November 2025. An order, my Lord, praying this very honorable court to refer very substantial constitutional questions raised in this very trial to the Court of Appeal. It is a constitutional application, my Lord, firmly anchored on section 295 sub 2 of the Constitution of the Federal.
Please identify all the pending motions.
All the pending ones, I will, my Lord.
Identify the one dated on 12th day of November. Can you identify them one by one?
It is a motion on notice, my Lord, brought pursuant to sections 1 sub 1.
Identify all the motions.
That is exactly what I'm trying to do.
Identified one.
The next one is a notice of the defendant's commitment to file a final written address. This was filed on the 11th day of November and dated on the 11th day of November 2025. That is the second one, my Lord. Dated 11th day of November 2025 and filed on the 11th day of November 2025, my Lord. Those are the two applications before this very honorable court.
dated on 5/11. There is another one. I don't know whether you want to abandon that one. It was filed on the 17th November.
That will be the motion to arrest judgment, my lord.
It has to do with motion for bail.
That is also there, my lord. I was hoping
identify them so that I know the number of motions I'm taking.
Okay.
You have identified 2.
Yes, my lord. This was dated. That's the motion for bail. Dated the 17th day of November 2025. Sorry. Dated the 25th, is it? Yes, 17th day of November, and filed on the 17th day of November, my lord. Those are the 3 motions I wish to move.
Yes, counsel to the prosecution.
May please, Your Lordship, we filed a reply.
Are you ready for those?
Oh, I am ready to argue the applications. Thank you, my lord.
Thank you.
Thank you, sir.
In interest of justice and in order to save judicial time, the 3 motions as identified by defendants are hereby consolidated for hearing. Defendants, can you proceed? Move those 3 motions.
Thank you, my lord. I shall move the motion on bail last. Let me move the most critical ones first. Here is not enough to contain my paperwork, so it's a bit muddled up,
Can I
my
tell
lord.
you one of your legal consultants to move to you?
Please, my lord.
Mr. Ejimako, can you move to the defendant you consult for?
I am praying, my lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, an order, my lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force, is unconstitutional, null and void, my lord, and for any other orders that my noble lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Nnamdi Kanu, and also by a written address which I urge my lord to accept its adoption, honorable lord.
Yes. You moved the 3 applications?
I have, my lord.
Thank you.
Thank you.
The prosecuting counsel, can you rehear to those 3 applications?
May please, Your Lordship. The prosecution filed reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your lordship to determine that in other ones. Well, the one asking for stay of proceedings, my lord, our argument is to the fact that the statute does not permit your lordship to grant any stay of proceedings or injunction. So we ask your lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter bill, the latter application with respect, is an abuse. In any event, none of them merits. We urge your lordship to dismiss it.
Please, let's save the time of the court.
We appeal your lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my lord.
Thank you, sir. Defendants, you have one or two words to say?
Most certainly, my lord, and I'm most grateful. My point is a very simple one, my lord. Very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my lord. And very finally, I think it is very, very important that I allude to what my lords...
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
My lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Okpara is okay. Where are the others? Ejiofor? Where are the others? Yes. You just have 2 minutes for this. Yes. Yes, up 2 minutes for this.
Thank you, my Lord. I'm most grateful. Once again, I will start with the bail application that I made. Since he did not file any counter affidavit, my Lord, he is in effect conceding. And I expect that this very application should be determined based on the affidavit that I filed.
You may sit down.
And on the issue of stay, my Lord, once a matter borders on jurisdiction, stay can be granted. Once it is a jurisdictional matter, stay can be granted. What I'm asking for is for a referral, my Lord, to the appeal court for the determination of these very key issues. And also, I reiterate that AJA is not superior. It is not superior to the Constitution of this very country, and an established jurisprudence as determined by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. And my Lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C45, my Lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't even exist, my Lord? It doesn't.
You are exceeding the 2 minutes.
Okay.
Can you summarize?
Yes, please. I ask, my Lord, that I be granted bail on very favorable terms, given that a concurrent judgment of the Supreme Court of Nigeria determined, my Lord, and found that I did not jump bail. I never did. That was their finding. I did not jump bail. And that the revocation of my bail implied that.
It's okay.
Thank you, my Lord.
Thank you.
Absolutely.
You may sit down. I'm going to read extempore as the application and all before these courts. The defendant filed 3 applications after the matter was adjourned to today for judgments. The defendant filed a motion on the 17th day of November 2025, seeking for 2 reliefs. 1, an order admitting the defendant's applicant to bail on liberal terms pending the determination of the invalid charge presently before this honorable court. The second relief is for an order declaring that the continued detention of the defendant applicant in the absence of a valid subsisting charge under a written law in force is unconstitutional and void. The second application is the motion on notice dated and filed on the 12th day of November 2025, seeking for two reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The second relief is an order staying further proceedings in the charge pending the determination of the referral questions by these courts to Court of Appeal. The third motion has to do with the notification to file written address. As defendant stated, he has put in his defense as his right to file written address should not be taken away from him. I've considered also the processes filed by the prosecution in reaction to some of the motions. In the application seeking to refer some questions to the Court of Appeal, the defendant submitted inter alia that the court cannot proceed to give judgment on a defective charge not founded on a written law, and that the court cannot rule on count 7 of the charge, contrary to the decision of the Supreme Court. I must say, most of the issues raised here in the application, save the application for bail, have been raised by the defendants severally in these courts. And these courts has made an order that all preliminary objections or issue shall be taken during the judgments. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings the statutory law governing criminal procedure in Nigeria, to wit, Administration of Criminal Justice Act 2015, by Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. These statutory provisions was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained, this court shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of this court, on the 27th day of October 2025, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relief is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. This court, in the interest of justice, will not close its eyes to see. The court will determine all this issue in its judgments. I proceed, I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not forget.
The defendant?
My Lord.
Consultant, can you tell your...
My Lord, please, let me finish.
Please.
It's my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, this very court, another affair that everyone was here, my Lord, another affair that everyone said, at the right time we will contradict or controvert the piece of evidence. A piece of evidence given to the court. I need to write my family to address my words
on a count charge which reads thus.
My Lord, I'm saying it clearly.
Defendant.
I'm entitled to family to address.
Defendant.
What is my family to address? It's in the Constitution. My family to address.
Defendant.
My Lord, my family to address. What is it?
Can you listen to the court?
Not, my Lord, please.
Can you listen to the court?
Please, my Lord. I need to find my family to address. It's in the Constitution.
I appeal to you to comport yourself this temple of justice.
My Lord, you are biased. You are biased. This is not law. You are biased. It's not law.
Please, I beg you to comport yourself.
My Lord, this is not law. Show me where it says you can waive my right to address.
Beg you to
show me
yourself.
Show me where it says you can waive my right to family to address. And I sit down.
You
show me.
In the
my Lord, you are conducting their case for them. You are preparing their case for them. Let them show me that the Constitution. Show me where it says you can waive my right to family to address.
You have the right to appeal after my...
No, my Lord. This is your perversion of the cause of justice. This is not law.
Can you excuse me?
My Lord,
excuse him.
Is that how you brought the cameras? Is that how you brought them today?
Please,
You didn't think it was busy before you brought it today?
please,
Show me where it says you can find me on the repeat law. Show me.
please, get the microphone from him, please.
I said show me. Show me.
Excuse me.
Show me.
Get the microphone from him.
No, leave it. Leave it. Leave it. I said leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial.
Please use the
I'm
microphone.
under trial. And I must address the court.
Please,
Wait.
can you listen?
No, listen to me. Please.
Please.
Judge must listen to me. Wait. Wait. I'm asking a very simple question. No, wait. Please, look, this is Supreme Court. Wait, hold on. This is Supreme Court here. Hold on a second. I said, hold on. May you please your lordship?
Please.
May I refer your lordship to section 366 of ABJA? It's not a court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me. I said, show me. When you have the right to go to my right to find my place. Show me. What the Constitution says. Show me.
Well, I will rise and come back.
You cannot show me.
Can you please take him out? I will come back.
You can't show me.
I rise.
Wait, hold on.
I'll come back in 5 minutes.
Don't see that one. Show me where it says you can break my right. Show me the place I'm asking you. Show me. Show me. Show me. Which law says you can try me an unwritten law? Show me you cannot show me and you're a judge. You can't be a judge. You don't know law. You don't know law. Nonsense. Where is the family address? Where is it? Which law gave you the right to go to my family address? Which law gave you the right? And you think I'm trying this? You want to try with me? Come off here, man. Come off here. What's this one doing here? What are you 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 doing here? Ask me what are you doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. Don't touch me. Don't push me. I'm going. Don't touch me. I'm warning you. Don't touch me. I'm warning you. Don't touch me. Don't touch me. Don't touch me. I said don't touch me. Don't.
Let him go by himself.
Mad people. You don't know law. Show me where it says you can wear my right foreign address. Show me the law. Show me the law. Oh, show me the law. You don't know the law. They are demoting you. You are writing rubbish. Show me the law. Unaddressed affidavit. You say you were doing their job for them. God will punish you now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him where is the law. Ask for promotion. Where is the law? Where is the law?
You give them the microphone. They are legal consultants to the convicts. They were lawyers to the convicts before he converted them to consultants.
Yes, my lord.
What is your name?
My name is Dr. Maxwell Opala.
Yes, the next person.
Alonji Mako is my name, Lord.
Thank you.
P-A-M-A-J-O-4.
Yes.
Prince Mandela.
Thank you. I just want it to be a record that he has a representative in court that will go and tell him, please, you may sit down.
Sorry, my lord. My lord, I don't have his brief to represent him here.
It's okay, you may sit down.
Azeko, please.
My Lord, Shem, we don't have his brief.
Why are you here?
We are here as consultants, my Lord.
I'm coming. This morning, when we started, you acted as consultant. You went to him, tell him what to inform the court. I have the video here. You moved from that place, you went to the convicts. You told him what to say. And I have to say this.
I have to take your direct instructions and directives, my
But
lord.
you are the consultant, are you not?
I am.
Thank you.
But we don't have his brief
It's
in
okay.
the main sense of it.
So it's okay. I'm just telling you so that you go and send him tell him this sentence. And I must say this: it is becoming getting to a level that I have to say this. We must act professionally. It is unheard that a defendant will, even in the open, slap his counsel to keep quiet while he's talking. The counsel must not talk. This counsel was disengaged, and some of them were converted to consultants, and they come to court to act as consultants, and they are lawyers. And Ejimako acted as consultant this morning and telling the court now that he does not have his brief. I'm not calling you as a lawyer. You have been converted to consultant that you ought to be, you oughted to be. Please, I'm just telling you, get the sentence to him. That is an order from this court.
Very well, my lord.
You are already here. Your name is on the list as consultants. As consultants all along. While he disengaged you, most of you have been coming as consultants. And I have it on record. It's not that the defendant has no legal access. He has access to legal experts. Please, you may sit down. Thank you.
My lord, we're just concerned that we're not being put in some kind of legal jeopardy.
You may sit down, please.
Thank you, my lord.
Thank you. Sentence. I read the entire file from the time the matter started in 2015. No doubt, the convict has not acted well throughout this period. He has caused delay severally. He caused delay and started crying that he's held unlawfully without trial. And also, his unruly behavior from the beginning down today, even today, is noticed. However, this court will not consider that in sentencing, as our God himself is merciful. He has been convicted, and this court is only being merciful to him because we have to be merciful as enjoined by our Lord Christ, Jesus Christ. The court is minded to sentence the convicts to death due to the atrocity he committed. The convict has not shown any remorse whatever for his actions. He remained arrogant, cocky, and full of himself without realizing the magnitude of his crime and the effect of what he has done against his people in the southeast. I've listened to the allocutors made by the member of House of Representatives representing the constituency of the convicts. Although I'm not really persuaded, but I must temper justice with mercy. The court is moved by chapter 23, verse 23 of Matthew, in the book of Matthew, to the fact that who unto you, scribes and Pharisees, hypocrites, for you pay tithes of mint and anise and cumin, and has omitted the weightier matter of the law, judgment, mercy, and faith. This you ought to have done. Particularly, must notice the word in Matthew 23 and verse 23, the word mercy. Our Lord himself is merciful. No matter what we do, is a merciful God. It is on that note that the court will follow this above admonition of Jesus Christ in the above passage and show mercy to the convicts. In addition, the death penalty globally is now being frowned upon by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and 6 instead of death sentence. Life is sacred to God. With respect to count 3, he is hereby sentenced to 20 years imprisonment without no option or fine. For count 7, he is sentenced to 5 years imprisonment without no option or fine. To extend the mercy, I hereby order that the sentence shall run concurrently. And due to the nature of the offenses that borders on terrorism and the attitude, violent nature of the defendants that I have taken judicial notice. The last adjourned date, he was so unruly and expressed violence, even was about to beat the security officers there. This morning, he repeated same. That has been his trait, his attitude. So I have no hesitation in coming to the conclusion that convicts has a tendency of violence. The tendency of violence has not left him. It is based on this that he must be kept in facility that is suitable for his custody, as putting him in Kuje Correctional Center may not be appropriate. And also, I take judicial notice and that from conclusion of the judgment and from the exhibits that I've analyzed in my judgments, substantially, the convicts made use of computer device like phones in making broadcasts to incite and call for all these atrocities. It is based on that without hesitation, I agree with the counsel to the prosecution that the convicts must not be allowed near any digital device, and if he must be closely monitored by the Office of the National Security Advisor. And also, with the atrocities, the number of killings, and the effect of the acts of the convicts on the people of Southeast, I think it deserved protective custody. Due to this offense, I ordered that if the convicts be kept in protective custody in any custodial center in any part of the country. And also, the objects of crime in respect of count 7 that has to do with the transmitter. The transmitter is hereby forfeited to the federal government. Thank you.
Thank you.
And regards other exhibits, if at the expiration of the 90 days is statutory time for appeal, if there is no appeal, an application may be brought for necessary consequential order. Yes, thank you.
Let me again, on behalf of the people of Nigeria, thank the judiciary for this development. It is now clear that law has its consequences, and anybody who breaks the law must be ready to face the consequences. And besides, law must be obeyed for the peace of the society. Law and judicial institutions must be respected to avoid anarchy and lawlessness. I want to thank you again on behalf of the people of Nigeria, the judiciary, for this judgment. I hope and pray that many others.
Now, but your client got life imprisonment. How are you going to react?
Today we forever live in infamy. Today is the only day I have witnessed a man being convicted for mere puffery, for what he said from his mouth, not what he did with his own hands. The verdict is not consistent with the evidence laid before the court. The sentence is overbroad, cruel, and unusual. How can you convict a man for making mere broadcasts from a location that was never named, and he never tied that broadcast to any single incidence of violence, or even someone slapping someone, not to talk of terrorism? You did all this, you didn't lay any evidence. I don't know where this whole verdict can be grounded in law, logic, or facts. We disagree with the judgment vehemently. Completely.
Yes.
And we are going to fight it from here onwards until justice is done.
Yes. There's no justice yet.
Yes. Suspect the judgment is not based on law. It's not based on facts. It's based on politics. It's based on some tribal, primordial sentiments. Just because Nnamdi Kanu is Igbo, an Igbo man has become the person in Nigeria that should be trampled upon. I'm not saying this because I'm Igbo. I'll say it for the Hausa or Yoruba who gets trampled upon. But today we saw an Igbo man being trampled upon, and by God Almighty, we are not going to allow it.
It will not stand.
It will not stand. Nobody is going to trample on me. Nobody is going to trample on Nnamdi Kanu. Nnamdi Kanu is not a terrorist. He's a man that was pursuing change. To pursue a separate nation of yours is not a crime. So in Nigeria today, if somebody says don't be silly, you get convicted. Nnamdi Kanu may broadcast, and so what? And you convict him for terrorism, for mere words in the Federal Republic of Nigeria. What kind of precedent is being laid? So from here we are heading to the Court of Appeal. The Court of Appeal is the only court in this country, or the next court in this country, that sits as a jury. We are going to approach the justices there to check out what happened in court today, and we are pretty sure the justices will agree with us that today was the symbol of the travesty of justice that everybody has been suspecting all along. If the Court of Appeal disagrees with us, we head to the Supreme Court. But by God Almighty, Nnamdi Kanu is not going to stand convicted.
Yes.
He's going to get overturned. Thank you.
I want to get something right. First of all, I want to talk to the Igbos that nobody should take laws into your hand. I'm assuring you, this judgment is predicated on anger. Thank God that the judgment was extreme life and everybody watched it. You will see the anger in delivering the judgment. And it's not predicated on law. Now, I also want to let you know that this charge, that the investigation that gave rise to this charge was not investigated, because Nnamdi Kanu's statement, purported statement, was rejected by this court. And they did not tender any document as investigation report. That is to say, the investigation was not, the offense was not investigated. Having said that, also something that happened in court today, Nnamdi Kanu filed a matter in court of appeal, and he is asking, my lord, that particular matter I filed in court of appeal anchored on this particular issue. Please, can you just suspend this judgment? Let court of appeal direct what to do. My lord refused. Now, on the issue of anger, you journalists will bear with Nnamdi Kanu that Nigerian government and the judiciary are not fair to Nnamdi Kanu. What do I mean? Nnamdi Kanu was given judgment by court of appeal. Federal government refused to comply with that judgment given by court of appeal until after 8 days before they appeal against it. When we get to the Supreme Court directed prosecution what to do. Amend this particular charge. Nnamdi Kanu was saying that, please, can you amend this charge? They refused. With the combined effect of all this, I'm assuring you that this judgment will not stand. And the court of appeal will do justice to it. Now, I also want to plead with judiciary. Nnamdi Kanu is representing himself, because the court has given the prosecution a blanket order to detain Nnamdi Kanu wherever they want. They should detain Nnamdi Kanu where we have access to file his appeal, because he has 90 days to file his appeal. And the judge said that the judgment will be ready in the next 15 minutes. I also enjoyed the media. We have the record of proceedings from the day the matter came to this place till today. I want you to check the record of proceedings and evidence tendered, reconcile it with the judgment. Now you now see what we are talking about. You are bringing British into this matter, bringing America into this matter. You are now trying to so that the British and America will be against Nnamdi Kanu. Something that was not an issue, that was not ever tendered, that was never given evidence on, and they are raising the issue. So this is a judgment against the Igbos. This is a judgment against the good people of Southeast, and it's because of Nnamdi Kanu is an Igbo. You cannot give this kind of judgment to a northerner. You cannot give it to a southwesterner. You cannot give it to another tribe in Nigeria apart from the Igbos. And we are going to start against it, because it has happened in this country against some other persons, including Abiola. The Igbos join hands together to fight against it. Why should it be our own time and everybody's sitting akimbo? It's unfair. Thank you.
Of defending himself, like cross-examining the witnesses, he did. But when you now ask somebody to defend something that does not exist, he will tell you that there is nothing to defend there. I think that is the message Nnamdi Kanu is trying to pass. The point is that for the judiciary, they felt they have a right as a judge, because the final say lies on the table of the judge. So you can say whatever you like. That's what is happening now, and that is what we've been witnessing in this country for some time now. Okay, the judges are abusing their rights. The judiciary is abusing the law itself. You can't make a law and go against your law. Now, you use one judgment for a particular person and use another. You are messing the judicial system. So that's what Nnamdi Kanu is protesting, because it's like he is helpless. So the only thing he can, what he's saying, allow me move my final address. That it is his right. That's the outburst. Because when they say there's an outburst, what is the outburst? The outburst is that, allow me, it is my fundamental human right. It is my fundamental human right that I move my final address. That is the outburst. And the judge is saying no. Now, what Nnamdi Kanu is trying to say is that the fact that you are a judge does not give you the right to go against the law that put you there. The judges, even though you are a judge and in any court you sit, you have the final say. but something gave you the power to have that final say. You cannot go against the law that gave you the power to sit in the court and pass judgment. So that's the outburst. That's what Nnamdi Kanu is challenging right now.
Is this a tribal issue? Because Kanu's brother is saying the Yorubas are against the Igbo.
Exactly. In fact, I made mention it in court. It's like the Yoruba nation and the Igbo nation are at war with each other. If you look at what is happening, you look at a government that will engage terrorists, the original terrorists that have killed before, and they say that they are now repentant. I mean, terrorists that will come out in broad daylight and claim responsibility for deaths. And they said they have forgiven them. Now, to worsen the whole thing, they said they had rehabilitated them and poured them into the Nigerian military. And how can the insecurity stop? Now, Nnamdi Kanu, go and listen to all the broadcasts of Nnamdi Kanu from 2014 till now. Everything that young man said is happening now. It's like they have a pre-information of what is going to happen, and they were just giving it out. Now, what is the charges, the terrorism charges that are carrying out against Nnamdi Kanu? Kanu told people, number one, during the NSAS, when the militaries were shooting at people at a toll gate, he said, defend yourself. He is not the first person that has said something like that. So the terrorism, he is a terrorist because he said, people, if the militaries are shooting at you, find a way and defend yourself and kill them too. That is the basis of the terrorism. Now, but people that have carried out terrorism, killed, like the general that was killed, somebody has taken responsibility. IPOP have never taken responsibility for any crime. In fact, what they keep saying is that we are not responsible. Nigerian security, do your job. In fact, they went as far as, in order to blackmail IPOP, did you know that the federal government engaged a Muslim jihadist in the person of Asedi Kibo to go and guide Southeast? Did you know that the federal they broke a jail in Imo State, carried all the criminals, handed them over to Asedi Kibo? He recruited them and poured them in Imo State. Did you know that the Bubago outfit is the outfit that the federal government used to carry out jihad in Imo State? And now what they were doing is that when they caged the media in Imo State, because when I confronted the media, why don't you report what is happening? They said they are caged, that they will only wait until the police release their report. It is based on the police report that they will write their own report. They caged it. They will perpetrate this act. The next thing you will hear is IPOP. Now, who are these IPOP? You say IPOP. IPOP say it is not us. Why don't you take time and investigate? It never happened. Do you know that in the East today, if anybody killed, they don't carry out investigation? So all they did is to do that to set Nnamdi Kanu up to kill him. Let me tell you, Nnamdi Kanu is the only one man after Otuku that Igbos are rallying around, have seen as a leader. So they don't want that to happen. And well, we don't know what they plan to do, but we are watching. We know what they want to do.
Your name, ma'am?
My name is Lolo Nneka Chimeze. I'm the president of Igbo Women Assembly.
The world, where is it in the world which was better than Nigeria? They couldn't establish that. Now, a few days ago, the prosecution came back and said, oh, you made a broadcast in Nigeria. Where is it made exactly? He must have to tell the court. But they are unable to provide all these informations because they don't have any. Also bear in mind that the witnesses they showcase in court, they are missionaries. They are missionaries. And that is why we have filed for perjury today at the magistrate court in which they are. So for how long would this evil keep going? Go everywhere in Nigeria, people are dying. Terrorists are killing people. Did Mazi Nnamdi Kanu kill anyone? The answer is no. So what is he doing in detention? It's an act of evil. Attack against Mazi Nnamdi Kanu is attack against the Igbos and the innocent people of this country. Those who believe in fairness and equity should rise up now and not tomorrow and speak against it. Thank you so much.
Thank you. You just heard from the brother of Nnamdi Kanu, that is person of Emmanuel Kanu. He's quite angry at the situation, at the entire outburst, and he's saying that it is warranted that Nnamdi Kanu is a human being. And of course, you know that some of these